Hey everybody, and welcome back to our third installment on trademarks in China. If you've been on this journey from the beginning, you're likely familiar with the process requirements for registering your trademark in China. Today we're going to get into what it takes to maintain the good faith of your mark and keep it safe from counterfeiters and infringers. Today is all about taking action. We're going to show you how to protect your mark proactively and reactively. Let's start with a warm-up. You've got your China trademark registered, so count to 10 years and renew your mark. And count to 10 years and renew your mark. Very good. If your workout were to end with the warm-up, it may be a long time before you see any results. The same is true with maintaining your mark. You need to actively protect your trademark. There are two areas of trademark protection we're going to focus on today: regular infringement and black market counterfeits. China is the top trademarking country in the world. 5.7 million trademarks have been filed in 2017 alone. With so much traffic, it's always possible for bad faith applications to slip through. There's also the problem of counterfeiting. Unfortunately, 12.5% of China's export in 2016 was counterfeit goods. With so many businesses and manufacturers, the black market knockoff business is booming, so policing your mark is an absolute must. There are a couple simple exercises you can do to strengthen your mark's protection. Subscribe to a monitoring service to get notified of any pending trademarks that are too similar to your own. Be quick to oppose any possible infringing marks before they hit the market. Pick up your legal weight and lunge. The second thing you can do, at very little cost and energy, is register your intellectual property with the General Administration of Customs. In fact, you should register your trademark with Customs in every country in which you are registered. You will need a local PRC agent to help you register in Chinese. You'll need to provide your name and contact information, your agent's contact information, you and your agent's business licenses, registration type, trademark registration number, a representation of your mark, a list of classes and goods, the names and pictures of the items you want protected with a description, your trademark registration certificate, and the time frame in which your IP registration is valid. You can also give the GAC a list of priority items you want to protect, as well as any and all information regarding previous or suspected counterfeiters. The registration costs 160 Canadian dollars and needs to be renewed every 10 years. The more you put into your registration, the better protection you get. These are the best actions to take to strengthen your IP protection, but sometimes, just through the sheer weight of business and manufacturing in China, a copycat or infringer will slip through the cracks. In that case, it is time for you to step up, take action, and exercise your trademark rights. Just so happens to be, China has several convenient systems in place to help investigate potential cases of infringement. Let's call the first system the cardio exercise. This is taking your case to the State Administration of Industry and Commerce, the SAIC. Why am I comparing it to cardio? Because it's quick and it doesn't require a lot of strength. First of all, SAICs operate by district, which means that there is far less traffic, so the whole process can take just 1 to 3 months. And of course, it's a lot cheaper than going to court. The SAIC is equipped to deal with non-standard use of registered trademarks, unfair competition such as counterfeit infringement, and infringement of trade secrets, as well as commercial disparagement, violation of advertisement laws, as well as unlicensed business activities. So, if you're a small business and you notice another company infringing on your trademark, this is the action for you. The second way to exercise your rights is strength training, using a little muscle. You would take a civil or criminal infringement case to the People's Court at the intermediate level, and appeals would go to a higher level. Recently, China has changed their policy so that trademark disputes can be heard by the Supreme Court. Civil actions take 6 to 12 months to be resolved, and criminal actions can take 3 to 6 months, once the case is accepted. What you must be wondering right now is what's the difference? Both the SAIC and People's Court deal with trademark infringement, and the SAIC is cheaper and a lot faster. Well, just like different exercises work on different parts of your body, the SAIC and People's Court are suited for different situations. The great advantage of the SAIC is that you don't have to show evidence of damages or proof of value in order to file a complaint, unlike in a regular court where your case only holds water if the infringement has hurt your company significantly. Even if you have not yet incurred damages, you can still bring in the SAIC to take administrative action. The SAIC is empowered to conduct raids, confiscate infringing goods, and find an infringing party. All you have to show is proof of infringement. But what if you do incur damages? The SAIC can slap a fine on an infringer, but they do not have the power to order an injunction or require the infringing party to pay compensation for damages and legal fees. That's where the People's Court comes in. If your company has incurred significant damages from infringement, you want to go to the People's Court. What makes the SAIC really useful is that it makes it so much easier to police your trademark because you don't have to wait to get hit before you can take action. It's proactive versus reactive. Here are some of the stats of what the SAIC has accomplished in trademark enforcement in 2016 alone. They handled 28,189 cases of trademark infringement, the total value of which was 354 million RMB. 293 of those cases were brought by the SAIC to the Public Security Bureau for Criminal Investigations. And the total value of those cases was 160 million RMB, about 27 million US dollars. So yeah, they're getting a lot done and are a valuable system to businesses in trademark enforcement. One thing to keep in mind throughout all of this is that it's always useful and often necessary to work with a Chinese agent, attorney, or agency with expertise in Chinese trademark law and, of course, Chinese languages and markets. Witmart is one of those agencies, with customer service centers operating across 106 cities in mainland China, as well as partnerships with top Chinese lawyers. That's all for this time, and we hope that you are feeling empowered by this knowledge to take action in any situation that might come your way when doing business in China. Next time, we'll be talking about common misconceptions and changing policies regarding China trademarks, so don't miss it. Thanks for watching.